SJC-12778, Commonwealth v. Dagoberto Sanchez.
Ms. Campbell, good morning.
Good morning. Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. With me today is Mark Lee, who is the trial prosecutor in the case. I'd also like to acknowledge Nicholas Brandt, who wrote the brief. We ask you today to reverse the allowance of the defendant's motion for a new trial and reverse the reduction of the defendant's sentence. This is a case in which the judge abused his discretion because he disregarded and overruled binding precedent and reduced the verdict in this case without legal authority.
What was the binding precedent that he ignored?
He ignored binding precedent from both the state court. From the state court, it was the first Sanchez opinion from the appeals court.
We declined further appellate review on.
You did. And that's
But if we were wrong, right? I mean, the Supreme Court of the United States said that one of the things that we did in our jurisprudence was wrong.
not
To the extent it was that likelihood as opposed to possibility.
I disagree that the Supreme Court of the United States.
About Johnson.
But in this case, in this specific case, Mr. Sanchez himself applied for certiorari, which was denied by the Supreme Court. So I would deny that. I would disagree with the assertion that the Supreme Court itself said that you were wrong. I also would disagree with the assertion.
We're bound by Supreme Court precedent, though, right?
I'm sorry. Can you repeat the question?
We cannot, as a state court, we cannot apply. We cannot misapply federal law, as the Supreme Court states the federal law is, can we?
Correct. But
Bound by the First Circuit, but its articulation of the federal law. But we are bound by the United States Supreme Court's articulation of it, aren't we not?
you are bound by that. I would say, though, that looking at the First Circuit's opinion in all stages of this, in the federal decisions on this case, there is no determination that the appeals court was wrong because of Johnson per se. It was looking at saying that the appeals court did not consider the factors in total as they should. But I think here's where it's important in this case, because the motion judge in this instance not only ignored the Massachusetts appeals court, which he was bound to follow, but he also ignored the ultimate determination of the federal court, which was that there was no constitutional violation in this case. What they did is
You mean after they had the remedy? After the remedy?
Absolutely correct. But what you have in this instance is two courts, two different systems, a state court system and a federal court system, which ultimately, though they get there through different ways, conclude the same thing, that there was no constitutional violation in this case.
But the argument from the appellees is that you'd never get to the point of the remand to Judge Saylor in the United States District Court. The remand, after finding a Batson violation, which obviously is the minimum of protection for the defendant, that we needed to a remand there for a race-neutral explanation, and then seeing whether that race-neutral explanation, whether it actually was racially purposeful discrimination. And the appellees are saying, once you have stage 1 SOARS violation, because there should have been a prima facie finding that at least the result of our cases has not been a remand, but structural error, new trial.
The result, correct, but I think it's important to look at the specific language that this court has used, both in Jones, but more recently in Ortega, and I would guide the court to footnote 10 of Ortega, in which it says, though the error is unlikely to be harmless, the court acknowledged that an evidentiary hearing was a constitutionally permissible option. So it's not that this court has held that a first stage Batson error necessarily is structural error requiring a new trial without any further inquiry. I would say that this case is unlike both Jones and Ortega. In Ortega, the court explained that it was not employing that option because there were other reversible errors in the case, which would have reversed the case anyway, and because no one had requested that below.
Have we ever remanded for similar to the federal court?
Not that I could find, no.
Counsel, in the bail hearing transcript, the trial prosecutor said you're looking for guidance on Jones. Can you tell me what the contour of that guidance might be?
Sure. The guidance that we're looking for is that the Commonwealth has noted the language that I just pointed to, both in Jones and in the cases before, and believes, as this case demonstrates, that a remand for an evidentiary hearing is not only constitutionally permissible, but is not, as the court said in Jones, that the conditions of impanelment are not necessarily difficult, if not impossible, to create. This case and what happened in the federal court demonstrates that assertion is simply belied. It's not different than any other trial that happens in the Commonwealth in which witnesses are called to rely upon past events and give testimony, which is either credited or discredited by the finder of fact. So that is the specific type of guidance that we are seeking in this case.
You want us to overturn in Jones, in other words?
No. I don't believe we want you to overturn it, because in Jones, the footnote does state that it is a constitutionally permissible option. We just want you to say that you can exercise that constitutionally permissible option.
Or have?
You never have, but I would point to, in both Jones and Ortega, the factors themselves of the peremptory challenge which were used. It says that there was nothing that indicated in the jurors' responses or any of the information that was known a race-neutral reason which would support that there was a race-neutral reason. Here, to the contrary, you have the individual, and this is the 12th peremptory that the prosecutor tried to use, his age. And age has been held time and time again to be a race-neutral reason, as the federal court found, to exercise a peremptory challenge. So I'd say, insofar as this case presents an opportunity for the court to recognize and hold that an evidentiary hearing is not only a constitutional permissible option, but an option that could be used. I don't think we need to get there in this case, though, because what the motion judge did was an abuse of discretion, because this case demonstrates why the doctrine of collateral estoppel exists. What you can't have is a Superior Court judge who looks at the appeals court and says, I think the appeals court got it wrong. He not only does that, he then points to the federal court and picks and chooses which part of their holding he wishes to apply to the case. You can't do that either. Even though it's not binding precedent, he ignores that the federal court found ultimately that there was no constitutional violation in this case.
Are you arguing direct estoppel or a collateral estoppel?
Direct estoppel.
Okay.
Because
not collateral.
Because this is an instance in which, and this is another error that the motion judge made, he said that this Rule 30 motion was the first time in which the defendant could raise this error, which is simply not true when you look at the record itself. He raised it in his direct appeal to the appeals court. It was fully litigated by the appeals court. They came down with a published decision, which is binding upon the Superior Court judge. He then, as he's entitled to do under the law, exercised his federal remedy, was permitted to fully exercise and litigate that remedy in federal court, which came to the same conclusion.
Except for they found that the appeals court was wrong, right?
They did, and though they found that A, under federal law, and B, the federal habeas review of that is not meant to be an appellate review of what the Massachusetts Appeals Court did. And in finding that the appeals court was wrong, they didn't find that the appeals court applied Article 12 incorrectly. They found that the factors that they looked at when looking at a Batson challenge, which is a different inquiry than the source challenge, was incorrect.
But that's the floor.
That is the floor. That is the floor. And I understand that. But this case demonstrates why Jones and Ortega and how these cases have been analyzed are problematic, because what you can have is an inquiry in which a race-neutral reason can be given. And in this case, it's even further supported by the record itself, because that the prosecutor was exercising peremptories based on age, and that this was a young juror is plainly apparent on the record.
So the prosecutor kept on pressing Judge Conley, I don't have to say the reason, I don't have to say the reason. And Judge Conley capitulated eventually to that. We've suggested it's better to have the reason stated so that there can be an analysis relative to adequate and genuine. But the issue here, trying to dig into that is that, so age is fine, but you can't consider age in a racially discriminatory manner. And isn't the First Circuit saying that as to step one, with the prima facie showing, there was enough to get into that, and that Judge Wilkins, putting aside whether you can do this with 25B2 or not, is saying, wait a minute, if the right finding had been made, the SJC's never remanded it for a hearing. It's been a structural error reversal, so there's a lack of fairness here, so I'm going to give the Commonwealth an option relative to retry and manslaughter.
No, because when you get down to the most basic, this case is hard to sort of conceptualize and figure out, because you have what are supposed to be two parallel tracks, and you have what is supposed to be binding precedent, and you have case law that has changed since this case was tried. Not changed insofar as arguing a new rule, but clarified and articulated in a different way by this court. But at the most basic level, what you have is a conclusion that there was no constitutional violation. And that's important, because what's unfair is that constitutional violation itself.
I understand that, I do, and especially with the remand and the findings by Judge Saylor after remand. I'm just trying to get at whether what Judge Wilkins did, knowing what he believed the reality of what would have happened had the appeals court made the correct determination on prima facie showing, whether what he did was violative of 25B2.
Of both Rule 30 and 25B2. I would say on the Rule 30 front, absolutely, because a Superior Court judge can't point to an appeals court opinion and overrule it. That's a basic tenet of law, and you don't want that to happen, and that's why collateral estoppel exists. What the judge could have done is said, I'm constrained by the appeals court decision, and entered a ruling in that way, or reported a question. There were many options in which he could try to get appellate review of that specific question. Pointing to the appeals court decision and him himself as a Superior Court judge declaring that it was wrong is not a permissible option under the law, nor should it be.
But if he had said, I'm constrained by the appeals court decision, it would still come to us in terms of denial of motion for new trial, and we'd still have to confront the same issue, which is this unusual part that the federal courts say it was a Batson violation. We said it was not a SOARS violation. It is, frankly, a lot easier for them to pull the trigger if they're going to remand it than it is for us to pull the trigger when it's structural error. So, I mean, that's the fundamental conflict we have, is that when we pull the trigger, historically, it's been structural error, and so we are perhaps more cautious in terms of when we pull the trigger than the federal court can be, because when the federal court pulls the trigger, they send it back to the district court, and the district court says, well, I've considered it all, and it turns out there's no constitutional error, and the conviction stands. So that's the dilemma we have.
I understand that dilemma. I'd say there's an easy solution to this dilemma, which is to recognize that this hearing is not only constitutional permissible, but should happen. I think
Why
that
should it happen? Why should it happen? I mean, that's the decision that the First Circuit made, right? That it should happen. They could have sent it back to us.
Well, they found that it was a violation.
Have to have the hearing. They could have sent it back to us. They chose to have their own federal court do the hearing.
Correct.
They could have sent it back to us, and it would have been structural error, and we would have given them a new trial, wouldn't we?
But I don't even believe the case law. It says it's unlikely that the error would be harmless. That's what I don't. I get.
Say prejudice is presumed.
Prejudice is presumed, but that doesn't
And
mean
that we favor this as structural error, therefore a new trial.
Yes, but I would ask the court to revisit that thought.
Why?
Especially because in an instance, especially a case like this, and this happens frequently, and you've seen it in murder cases, where there are just race-neutral justifications that exist. Race-neutral justifications, such as this case, age, which would support a race-neutral reason for striking a juror. Because the prosecutor was not asked, and there was not a pattern found to provide that justification, does not mean that he should never be able to provide that justification.
Could the trial judge have ordered, because of this sort of difference between federal and state law, could the trial judge have ordered a new trial? What he did, I assume there's absolutely no authority for this. But I'm trying to think, could he, given this difference between state and federal law, have ordered a new trial? Would that have been a permissible act by him?
No,
You mean Judge Saylor?
No, I'm talking about
No,
Judge
Judge Wilkins.
Wilkins.
Okay.
not on the federal grounds, because there was a federal,
Not on the federal grounds,
on
but
the
on the
state
state.
grounds?
Yeah, that's what I'm wondering about.
Couldn't he have done it under Rule 30?
Yeah.
I
Could he
don't believe so. So it's, I don't believe so, given the appeals court binding precedent.
Even though the feds have said the appeals court's goofed up, he couldn't I mean, I have real problems with what he did under Rule 25B2, but I wonder whether he could have ordered a new trial because of we're more generous under structural error and order, sort of automatically ordering a new trial.
Sure, but again, no, I don't believe so, because if you look at what the question is, it's whether, I understand that Rule 30 provides a mechanism where they can ask whether justice was done. What you have here is, even though there was a determination by the federal court under federal law that there was a first-stage Batson error, there also was a determination, which is being ignored by the motion judge below, that there was no constitutional violation at its base. And so really, the question is, what is Batson and what is SOARS meant to
But
protect?
your position is, even if it was under Rule 30 for a miscarriage of justice, it would have been legal error?
Correct.
Because at bottom, the federal court found there was no constitutional violation.
Correct.
Chief, I know we're running tight on time, but can I ask one question, which is, are there any other cases where we have held that structural error does not require a new trial, where we've found structural error to be harmless, or is everything that's structural error automatically reversed?
I don't want to misspeak, and that's an excellent question. There are instances in terms of waiver, for example, you can waive structural error. I don't know. I'm happy to provide the answer to that question in a 16L letter. I simply don't have a full.
The feds have said that absent waiver, at least on a direct appeal, or when it's consolidated, that you have to reverse, right? They say that in Weaver and some of these other cases.
I need to read Weaver again, and I need to look back.
And that's why it's called structural error.
It is why it's called structural error, but then I guess I question the court what that.
Right, I mean, the question is not really whether structural error requires reversal, at least in my mind, structural error requires reversal. The question is whether or not we're going to call it structural error, or whether we're going to permit a remand, as the federal court did, to resolve the issue and say it's not structural error. It can be resolved 7 years later in a different court with a different judge.
Correct, but the same prosecutor, and I would say to the extent that Jones and Ortega recognize that there's a constitutionally permissible option, and that although it's unlikely to be, the error is likely to be harmless, that there is this avenue by which the Commonwealth could prove that it is harmless. I'd say it was able to do here. That should be a option going forward in cases, and it necessarily isn't structural error by the very terms that this court has used in its own cases.
So I will burden you with one more question. Sure. Doesn't this case illustrate that perhaps we should abandon the first test of SOARS and simply say, when there is a claim that a prosecutor used race or gender in a peremptory, to have the judge ask for an explanation as opposed to finding a pattern and walking into this mess each time? We've sort of said in ISSA and at other times, please, judge, when it's asked, if it's at all close, please ask for the prosecutor to do this. Is it time for us to say, you don't need a pattern, you don't need a prima facie case, you just need a good faith objection, and then the prosecutor should do it?
So my response is yes, it obviously would be easier for all of us standing here to analyze this. My hesitation is the purpose of peremptory challenges itself. It then becomes not a peremptory challenge, it becomes another for-cause challenge. So to the extent that the court wishes, and there's a statute which permits peremptory challenge to keep peremptory challenges, then I'd say that the very nature and the very definition of a peremptory challenge doesn't require such a.
And bump into each other, though, don't they?
Yeah, but I mean, you have employment at-will contracts, but an at-will contract means you can be fired for any reason, but not
Yes.
for
yes.
race or gender. So there are other contexts in which we have said you can use any reason, you just can't use a forbidden reason.
Correct. I question what the threshold would be then.
Well, the question, though, is, it's a hard question to answer, I think, for you right now at this very moment. But the problem is that you've got these structural errors and this reversal, and you're saying, well, how about a remand? And you don't need the remand. You've got the information in the record that can be analyzed, and this all or nothing, or the trigger, as the chief referred to it, all of a sudden doesn't have as bigger bullets.
Well, I think here there's an apparent justification on the record. So the problem I have is I disagree with the federal court determination anyway, because I think the race
For
neutral
circuits,
reason.
you mean for circuits?
The First Circuits, yes. Because I think the race neutral reason is apparent on the record. But this demonstrates, I can't get away from demonstrating, it demonstrates, at its very basic level, where the federal court permitted this type of evidentiary hearing and where there was a conclusion that there was no constitutional violation. I think it demonstrates the problems inherent with the way that this court has analyzed it this far. Again, I question sort of what the purpose of Batson and Soares is at all, if the prosecutor, though the court may decide that a prosecutor has to give an explanation every single time, that wasn't the case when this case was tried.
Well, in fact, as the history of these cases have evolved, there was a period of time when prosecutors were encouraged not to give a reason unless the judge found a pattern.
Absolutely. So it's sort of tying everyone's hand behind their back because they were acting based on what the law was at the existence of the time. It doesn't seem necessarily just or fair, especially, I don't want to point to homicide cases to the exclusion of all other cases, but they are a unique type of case to then hold because no one was being held to that standard, that standard should apply after the fact, seems incredibly unjust.
Do you think the fact that the defendant only can take a motion for new trial through a gatekeeper puts more pressure on this issue?
This is a second-degree case, so he was entitled.
I'm sorry, right.
Yeah, he was
You're right.
entitled to appeal
You're right.
regardless.
So he was fine.
He was fine.
Can I ask a practical question?
As opposed to the impractical ones that have been asked before.
Mr. Sanchez is out right now?
Correct.
You're not saying that he should be resentenced and put back into prison, are you?
Wait, what the Commonwealth decides to do post this, the Commonwealth is concerned with this case because of the motion judge's actions and the importance of the issue to almost all of the cases that we try. I can't underscore the impact that this has had, especially on Suffolk County, with the homicides that we have prosecuted for years back. It's had an immense impact, and I can't tell you what that has done to the victims' families of these crimes. But I would say that
I'm confused. Why does this have widespread impact? Are they
Jones-
doing, are the Superior Court judges doing this 25B2 sort of 33E review?
They're not, and part of the reason why this appeal is so important is to tell them that they cannot. We have had certain judges point to this opinion and try to use it, but there are other instances in which the court has looked at Jones and Ortega and reversed first-degree homicides and homicide cases on that basis. So I say that it does have an impact on homicide cases that were tried prior to this, although it doesn't announce any kind
Going
of new
back
law.
to Justice Budd's.
Yes, the practical
question is, in terms of Mr. Sanchez, if you prevail, he's back in jail.
If we prevail, yes. Now whether, and I don't think that that's any different than any time a defendant has a stay of execution of sentence or is subject to a retrial and gets out on bail prior to that retrial. I don't think that this is unique under the law.
Ms. Greenberg says you don't prevail because you didn't ask for a stay. There was a 15-year and a 15-year day imposed, and it was served.
Yes, and I disagree with that. The Commonwealth, upon getting this decision, filed a notice of appeal before the resentencing, objected to the resentencing, and filed a notice of appeal of that resentencing. This is not an instance where the Commonwealth has to exhaust every single remedy
Wouldn't it have been sensible to do a stay, though? Wouldn't it have been sensible?
Your Honor, a stay in terms of the resentencing?
Yep.
Though that it could have been an option, it doesn't preclude the Commonwealth from raising the properly.
But the Slavka issue,
The what issue? I'm sorry.
Slavka.
I don't understand what you,
Double jeopardy.
this doesn't, there would be no double jeopardy in terms of retrial. It doesn't hit any of the three evils that double jeopardy is meant to protect against. It's not a second prosecution for the same offense after acquittal. It's not a second prosecution for the same offense after a conviction, and it's not a multiple punishment for the same crime. It's punishment tied to the same crime. It's the same as any defendant being resentenced after an vacating of his first trial and subsequent prosecution and conviction again.
Okay. Going back to the practical.
Yes.
If you do prevail, which you sometimes do, and he goes back to jail, does he get credit for the time that he was on the street in terms of parole eligibility?
That would be a question for the parole board, I think.
Is the question for this court? Because it would mean that all that happened would actually mean that he would be.
He would be penalized for exercising his rights. Correct. I don't know the answer to that question. I don't know how the parole board would view that question. I think, there could be a separate action based on that with the parole board justifying why they would not credit that time or not credit that time.
Okay, thank you.
Thank you.
Ms. Greenberg.
Thank you. I might need a couple extra minutes. I want to answer questions that you asked my sister. The answer to to your first question, I think Judge Seifert gave you, which is where there's structural error, unless there's waiver, there is reversal. That's the meaning of structural error, and that's Weaver versus Massachusetts, which was my case I lost, so I read it a lot. It's structural error is reversal unless it's waived. And this court has repeatedly decided that the failure to do a stage 1 Batson inquiry when the facts support it is structural error and requires reversal. We didn't mention Robertson, but in Robertson, which is recent, the Suffolk County made the same argument that they're making to you today, and I'm sure the court carefully considered it in Robertson, and the court said, no, we're sticking with structural error. And I want to be careful, so that answers, I think, those questions.
But we do have, she is right about Ortega Note 10.
She's right about Ortega Note 10.
Possibility in some circumstances that we might possibly do it. We never have, but
But you never have.
it does recognize the possibility.
It's federally, constitutionally permissible. So far, the Declaration of Rights has not permitted it in terms of, we don't. We never have. So Mr. Sanchez would be the only person ever in Massachusetts jurisprudence
So we
to suffer.
haven't, I think, not as a constitutional matter, but as a matter of practicality, that we just
And I want,
don't think it's, 7 years later, going back arguably to a different judge. Mr. Lee is a warrior, having remained in the DA's office for that long, but not many do, so arguably you'd be pulling an attorney out of private practice and having the attorney come back to a different, there are practicality problems generally in us doing it. Is it a constitutional issue? Are we forbidden to do so constitutionally, or do we just say, really, it's not sensible?
it's not decided as a matter of federal Supreme Court law. You couldn't win it on habeas. The circuits are split. The states are various. The First Circuit opinion in Sanchez 1 lists the states and circuits which differ on what is constitutionally required, and there is a split. I'd love to take it up. Invite me. But in the meantime, the Massachusetts rule is structural error. I do mean to preserve that federal question, joking aside. And I do want, I'm going to answer Justice Budd's question, and then I'm going to come back to Justice Gantz. It would be and also to to Justice Lowy, yes, there is a double jeopardy prohibition against punishing Mr. Sanchez further.
Why? He was convicted.
Because he was
Well,
sentenced.
if we conclude that the judge was not authorized to use 25B2 to change this from second-degree murder to manslaughter, we're just putting back the original verdict. How is that a double jeopardy problem?
He can be tried again under, if you say the judge was correct to grant relief in this case, which is a separate question than what the relief is.
We have another option too, which is just to say, basically what your sister just argued, that there wasn't, because the feds have gone through their process, and Ortega footnote 10 provides that as an option, the judge should not have done 25B2, and the case should be, back to where it was before. That's not a double jeopardy problem, is it? It's basically just saying the judge shouldn't have done what he did.
Would you allow me to
Oh, yeah.
speak to a different, to go backwards a little bit on the explanation?
But I would like you to answer that question. Go backwards as much as you want, but answer that question too.
Yes. When my sister says a finding of constitutional violation, we're eliding two separate constitutional protections. One is the protections which are guaranteed by Article 12, and the other is the protections guaranteed by the federal Constitution. As Justice Gaziano pointed out, the federal Constitution provides a floor and not a ceiling. So when the federal courts said that...
Not if we have a footnote that opens us down to that floor too.
Not to the remedy, but as to whether an inquiry needed to be made in this case, as to what the prosecutor's motivation was. The federal courts said that the United States Constitution requires an inquiry be made. That means that the state constitution also requires an inquiry be made, because a state constitution can't require less than the federal constitution does. So the federal courts have said that in this case, an inquiry was required. Once we accept that an inquiry was required in this case, and this court, by repeatedly citing Sanchez as authority, has accepted that an inquiry was required in this case, that under Johnson, as Justice Link points out, first stage inquiry was required. It's required by the state constitution, because the state constitution can't require less than the federal constitution does. And once we've established that a state constitution here also required inquiry, then this defendant...
But isn't that the issue, is whether this footnote, which we've left open, provides us the ability to basically rely on the federal evidentiary hearing. I'm not saying we should have, I'm not saying the trial judge, the motion judge was mandated to do that, but it seems like that's a possibility. It's not a state, our state constitution may allow what the feds did.
The state constitution requires a state remedy for a failure to follow what the state constitution must require.
Even if the federal remedy is exactly what the state constitution allows? If we adopt footnote 10, that would be, couldn't we just piggyback on the feds?
You would, if you were to do that, you would basically be creating what a forbidden rule of attainder. You would have a rule that retroactively applied to imprison one person.
So we'd have to remand it again.
Except that you don't have to remand it again.
No, I mean, just
yes, if he did, if you were to do that, you would then have to remand.
Right, so hypothetically, I'm just...
Yeah, hypothetically, go
So
backwards, retro, and remand.
If we said Ortega 10 governs, goes back.
Right, goes back retrospectively.
To another
You
hearing.
would then have to have a state evidentiary hearing with a state court determination. And Justice Wilkins quite appropriately said that Mr. Sanchez is entitled to the state court determination which Justice Connolly wrongly denied him. And Judge Connolly wrongly denied him in error, and because he never got a state court determination which he was entitled to, he's entitled, like everybody else in Massachusetts who didn't get a deserved state court stage 1 hearing.
He's entitled to
a
have
remedy.
have the trial judge decide to lower the verdict. Any case in Massachusetts or anywhere that allows that? You got anything to rely on that we can look at?
To answer your question, is 25B2 an appropriate remedy? That's why I asked for direct appellate review on this case. That's why,
So
because
is there a case?
because we're-
Again, I'd like,
Yeah.
the chief has this wonderful question that I always like, well, try my question. So try my question on this one.
yes, Woodward. In Woodward, in fact,
Woodward, the trial judge is authorized under 25B2 to do this?
a trial judge can reduce until Roland.
That was done on evidence, wasn't it? Woodward was lowered on evidence?
In Woodward, a list was given for all the, this is a much larger question, separate and apart from Sanchez. What is the authority of 25B2? And can the courts use 25B2? Is it in fact the cognate of 233E review for a trial court? And can it be based on something other than the evidence at trial? And until Roland, it could be. So if you look at Woodward, you can see this court saying, on what basis can a trial court reduce a verdict? And there's a list, and it's in my brief. And the trial court, until Roland, never said that it was limited to the weight of the evidence. That was the first time. That was Justice Sussman limited 25B2 for the very first time. And my suggestion would be...
Was she limiting it or just articulating what was a common understanding of that rule and in the mind of, bearing in mind that Woodward in fact was done on the evidence? I mean, I'm not sure she was limiting it.
There's a list in Woodward of all the reasons you could.
And what reason does your case come under in Woodward?
I'm sorry, Judge, I'm sorry, I have to look at my list. May I answer that separately, because I don't want to take my time? But it was not intended as a limit. It was intended to be as broad as 33E. 33E is not like in Commonwealth versus Colleran. 33E looks at all the reasons on a plenary record why justice might not have been done. And this court...
There's a case that says that 25B2 is comparable to 33E?
Every case says.
Except
How
for
about
only
Gilbert?
on
What about
evidence.
Gilbert?
I mean, Woodward factually, I've not gone back to the opinion for a while, but Woodward factually doesn't help you, because what Judge Zobel found is based on the evidence in that case, it was more appropriately a involuntary manslaughter. What was screwy about the case is that the defense didn't ask for that instruction, and he had to reduce it to a crime which the defense affirmatively said we don't want the jury to have the option to do. But it was based on the evidence of the case. What's complicated here is that if it is structural error, it's a new trial. We don't say it's structural error, so we're going to basically order you to be convicted of a lesser crime. It's generally a new trial, period. That's what is different about this case.
But the rule of Woodward, which embraced the history of 25B2, is not limited to the facts
Well,
of
you know,
Woodward.
this must be footnote 10, Dave, because in footnote 10 of Woodward, it says, to your point, the authority of a trial judge under 25B2 to reduce the verdict or grant a new trial is much like our authority to review so-called capital case convictions of murder in the first degree under Chapter 278, Section 33E.
Yes.
Don't you want to be careful what you wish for? Because if he hadn't served, if he had only served 2 years, and if the judge said structural error, but I'm going to now say it's voluntary or involuntary manslaughter and say 15 years, you would go nuts.
You
would
have
say-
already upheld the authority of a trial court to do that. In fact, Judge, I think it might be your case. I'm searching.
I can't, in my younger days, I made many errors, but I can't imagine that I would have done that.
This
It would be fundamentally unfair if he was to serve 10 more years in prison when we had found structural error and therefore found that the case required a new trial, to say,
Judge,
well,
I would not suggest it be permitted over the defendant's objection. I would suggest that 25B2 be an appropriate vehicle when the Commonwealth is offered the opportunity to elect, as it did here. If this court were to say, Mr. Sanchez must be retried, I am content. I'm content with that. So long as we all understand, and this is where double jeopardy and Salafka and the Smith case at SCOTUS and Benz versus in 1935 say, sentence has been pronounced on this defendant, whether or not it was pronounced in error. And my duty of candor to the court and my duty of candor with Judge Wilkins, I don't actually think a sentencing was appropriate here. I think Rule 30C-8A precludes it. And I thought I was going in asking for bail. And I filed a motion for bail, and I asked for a hearing on bail, and everything is marked bail. Because I think the appropriate action to take here is bail, and that's what I told the court.
That's what I'm somewhat confused over.
It's confusing.
In the 25B2 context, if a trial judge is confronted with what a trial judge believes, and I think Justice Wilkins gets to this, that there was a miscarriage of justice given what happened in the federal court and the appeals court ruling, the judge is perfectly authorized to grant a new trial for a miscarriage of justice under Rule 30, correct?
Correct.
And your assumption was, under Rule 30, that's what he was finding, the remedy was a new trial.
Yes. And that he offered an election. He offered.
But, his authority to do so is frankly dubious, but that's.
Well, but in this case, he believed it to be, and I'm arguing he was correct because of the.
Now you think he's right.
Yes. Well, he was right. No, he was right to grant relief under Rule 30.
Right, correct.
And then he offered the Commonwealth to elect a remedy. He didn't say to the Commonwealth, I'm definitely reducing it under Rule 25B2. He said, up to you, just like this court says to the Commonwealth under 33E.
I guess that's almost subsidiary to your first argument,
Yes.
that he gets a new trial.
Yes, yes. You say, when you say there's an error in the instructions on first-degree murder, you say to the Commonwealth, either you have an option. You can let this be a murder too, or you can retry it.
Right,
You
but
got
that's-
3
but
months
that's
to
because
decide.
the error relates.
Right.
That's because the jury indisputably found at least murder 2, and the error concerned whether or not it was appropriate for them to find murder 1. So, but in this case, if it's truly structural error, then the trial itself was unfair and no sentence is appropriate. It's perfectly fine to say motion for new trial, and you can plead them out
So then the
involuntary
Commonwealth
manslaughter.
should have elected retrial. And they had from, I think, August 29th to October 10th to elect retrial, and then there would have been no question about the scope of 25B2. And if the Commonwealth objected to 25B2, their choice was to elect retrial and then appeal under Rule 15 that judgment. But they did not elect retrial, and the judge's option was self-executing by nature. So they failed to do what they say now the law requires. That wasn't my error, none of it.
Are you saying that if we find that what the judge did in reducing the verdict was error, we cannot order a new trial now?
I'm sorry, we can have what?
If we say that what he did was wrong in terms of reducing the verdict, can we still order a new trial?
Yes, have at it. Order a new trial. The only thing you can't do now is put him back in jail. And the reason you can't put him back in jail is because the Commonwealth waived that when they failed to argue Rule 30C-8A and failed to insist that the judge not sentence.
Can he be resentenced?
He can't be resentenced to more.
Okay, that's, yeah.
Yes.
When
he
you say
cannot-
he can't be resentenced to more, you're including that he can't be resentenced, assuming that he was paroled, to being on parole. Your view
He
is.
could have a
Your
man-
view is it's 15 to 15 in a day, and anything else is double jeopardy, multiple punishment.
He can have, yes, he can have, in the unique circumstances of this case, we accept a retrial, we're eager for a retrial. I don't think he could be convicted again. We're happy to have a retrial, but following the retrial, his sentence cannot be increased under the doctrine you've set forth in Sevlaka, which is the iteration, the federal protection against being sentenced twice for the same thing.
But isn't the Wilkins sentence a nullity because it was unauthorized?
No sentence is ever a nullity. He served it. He can't receive a sentence, you can't just say,
Because I assume he got a life sentence on the second degree, right?
I'm sorry?
The first time he was sentenced was to life on the second degree, correct?
a sentencing in the Superior Court is a pronounced sentence. It has jeopardy attaches to the sentence at the moment the judge pronounces sentence. The judge may not have been correct in pronouncing sentence. The Commonwealth can appeal an illegal sentence under Rule 29 and did not. The Commonwealth can bring an emergency motion. The Commonwealth here, in order to preserve its rights, should have cited Rule 30C-8A. I myself told the judge this should be a bail judge, not a sentencing. It doesn't preserve the error for the Commonwealth, but what we have here is a reliance on, I understand that there's a difference between form and substance, but when a sentence is pronounced, that sentence is final. And Mr. Sanchez is entitled to finality of judgment, just like any other sentenced person. No, his sentence can't be a nullity. It was pronounced in open court with the gavel, and he was released on it, and he served it. We can't
When
now
you
say
he can't-
sorry.
When you say he can't be sentenced to more, you mean he can't go back to prison regardless of what a second trial brings?
Yes.
Okay.
Because he has completely served the sentence pronounced by a judge of the Superior Court.
You mean Wilkins?
Yes,
Yes.
yes, Wilkins sentenced him. That was a sentencing.
Can I ask a question, please? I know this is simplistic, but I'd like you to go through the analysis of why it is he's entitled to the new trial, or because I want you to take the Commonwealth's analysis, which was basically that the appeals court in Massachusetts issued a judgment that was never really tipped. It's in effect. The appeals court judgment in Massachusetts is in effect, notwithstanding what the First Circuit has said about the errors in it. We don't have to adopt the First Circuit's iteration of error.
If that were true, then habeas could never be granted. In this individual case, the First Circuit said under 2254 that the Massachusetts court was unreasonably wrong in applying federal law.
Well, but I think the Commonwealth is arguing, if I'm not mistaken, that Judge Wilkins did not have the power to override the appeals court's decision in Massachusetts.
Judge Wilkins didn't override the
He said it was
appeals
wrong.
court condition.
He said it was wrong. He said a decision of the Massachusetts appeals court,
The
which has never been overturned.
the First Circuit in Sanchez 2014 said the appeals court was
What do
wrong.
we make of that, though? What does the state court make of when the First Circuit says your decision is wrong?
The state court is obliged to follow it and in separate parts.
Always, not necessarily because of well, why is it that a state court has to listen to what the First Circuit has to say?
Because that's the power of habeas granted by the
First Circuit
Constitution of the
the
United
First
States,
Circuit-
limited by AEDPA to what's unreasonably wrong, which is what the state court was here in refusing to grant a stage 1 hearing because of discrimination in jury selection. The federal court says this under 2254 that the state court erred.
And then
And
it
that
provides-
ruling
then
is
it
binding on every action in Massachusetts, in this case, as to the state court's failure to inquire of Mark Lee. That's binding on this court. If the federal, otherwise, if what my sister suggests is true, then there could never be a grant of habeas. If the court, for instance, if Judge Saylor were to have found that there was discrimination in jury, that the found as,
Sends it back for a new trial here, right?
yes, because he would overrule the Massachusetts Appeals
And we
Court.
would have
That's
been
what habeas
bound, we would have
does.
been bound to do that?
Pardon me?
We would have been bound to grant him a new trial also?
Oh, yes. If the federal court habeas overrules, that's what habeas is. They say to go to the federal court, staying to the state court. This
That's
is
not the-
error.
well,
Yeah, but
well, the
usually-
habeas was denied.
Habeas was denied.
Usually, we abide when they say when they reverse it, but in the end, they affirm it, so it's much
But
more
you-
complicated than
You
usual.
have to abide by both parts and sections.
Mm-hmm.
You have to abide by their ruling that there was error in the failure to hold a stage 1 hearing, and that the decision in Sanchez, State Court Sanchez decision was wrong on that question, because the federal court has said the state court is wrong that in the failure to hold a stage 1 hearing.
And the state must comply with that.
Yes, that's habeas. They have to apply, for instance, if they had held that the counsel was ineffective in failing to do an inquiry, you would have to grant a new trial.
How come we don't have to follow the United States District Court judge then, that held that there was no racial discrimination?
Because it's a 2-part analysis.
No, I understand that, but the habeas was denied. And so the decision from the United States Court of Appeals, the First Circuit, was that, no, the conviction can stand.
But the denial of habeas, the eventual finding that there is not binding on this court as to Article 12. What's binding on this court is that the failure to hold an inquiry was error. That's binding on this court. Forgive me, Massachusetts was told by a 3-judge panel of the First Circuit that the failure to hold an inquiry violated the Constitution of the United States. When the federal court holds the failure to hold an inquiry violates the Constitution of...
But it's not what it said. It said the failure to hold an inquiry on Batson Stage 1 requires a remand to make a determination as to the reason and whether it was racially discriminatory. That's not what the First Circuit said. What you just said the First Circuit said is not what the First Circuit said.
Judge, the reason that they sent it back for the inquiry.
I completely understand your argument that we have disfavored having a remand. I understand that. But you can't say that the First Circuit said the conviction was wrong. You just can't say that and have it be true. The habeas was denied. I appreciate your argument that you know, what the United States Court of Appeals had to say about Stage 1 SOARs is something that we need to be cognizant of. But that doesn't mean that the First Circuit said the conviction is wrong and the habeas is allowed.
Not that the conviction is wrong. Because I'm not saying that the federal government said the conviction is wrong. What the federal government said, which is binding on this court, is that the failure to hold the inquiry was wrong.
Okay, thank you.
Thank you.